All right, y'all, we are back, and quiet as kept, Heavy D was sued for the basketball game that Sean Combs had at City College of New York. And I was not aware of that. I was doing my research and I found that he was indeed sued because he was a part of the event as well. So I'm going to read this right here. What happened was we saw what happened with the City College basketball game. They oversold. Too many people were there. The people were unable to get out. They got trapped and they were trampled with 8 or 9 people dying. As a result, those individuals were suing Puffy and they were suing Heavy D. Okay. So, in order to pay them out, Heavy D was relying on his insurance, his entertainment insurance. The insurance said, oh, no, 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 we're not going to pay that. However, it looks like the judge ruled that they, in fact, have to pay. So, he had to pay, him and Diddy had to pay 50%. I think it was $3.8 million in damages that they had to pay. And I can also link to that complaint because I was reading it this morning, but it was $3.8 million that for total damages, right? This is before individualized complaints. So 3.8 million for the total damages, and then City College, right, was responsible for 50%. And then Puffy and Heavy D were responsible for the remaining 50%, so 25% per person. All right, so let's get into, that's the wrong tab here. Okay, here we go. So National Union Fire of Pittsburgh, that is his insurance company. His name is his real name. Yeah, Pharrell Myers, doing business as Heavy D. Okay, so this is from 2004. Now we remember he died in 2006. Okay, so he's been dealing with this for a long time because that happened. That basketball game happened like before Diddy really was Diddy. Like this happened a long, long time ago. And as you see in the documentary, it says this, that happened, and then he became who he was. He was known for that basketball game. Okay, so the plaintiff, National Union Fire Insurance Company, seeks a declaratory judgment that defendant Heavy D is not entitled to coverage for liability arising from the catastrophic results of the City College stampede. This matter was tried by the court without a jury. National Union and the defendant submitted a stipulation of agreed facts with agreed to exhibits in evidence. National Union produced no witnesses at trial. Heavy D produced one witness, an insurance broker who offered testimony on the meaning of various provisions in the insurance contract. Co-defendant Sean Combs contracted with the City College evening student government to put on a celebrity basketball game to take place at the college's Nat Holman Gymnasium. Combs and the student government were the sponsors of the event. That's important. The student government was to provide the facilities, while Combs was to provide insurance, 20 celebrities, promotional materials, and the need of the artists involved, contracts, etc. Heavy D was recruited by Combs to coach one team, while Combs was to coach the other. Combs provided the promotional materials for the event, such as circulars. Heavy D appeared on a radio station to advertise the event. A huge crowd appeared for the game. When all could not gain interest, pushing and shoving ensued, which eventually resulted in a stampede with a number of deaths and injuries. Heavy D and Combs, among others, were sued for the injuries and deaths resulting from the stampede. Plaintiff National Union provided representation to Heavy D. During the course of litigation, National Union informed Heavy D in a disclaimer letter that it would not indemnify Heavy D on the ground that self-promotion and a failure to report a concert in advance of the event were items excluded from the insurance policy. So they're like, look, we don't have to pay out for this. You have to pay out of pocket for this. You have to pay out of pocket for this. We're not going to do it. They're representing him, but they're like, this is not our responsibility because you did not report the concert in advance. Okay? And self-promotion. They're saying that he was promoting himself. Not that he's promoting the actual event, but that he's doing self-promotion. Okay, this action for declaratory relief is predicated on those exclusions, and National Union also advances at trial an additional theory of exclusion, claiming that the relationship between Heavy D and Combs was one of a joint venture. So now they're saying this was your party too. Not that you were asked to be a coach, but this is also your party. And we have to remember at this particular time when the party's happening, Heavy D was on top of the world. He was the first artist at Uptown Records. Like, he was really setting the standard for Uptown. Okay, so as a result, Combs' unchallenged status as the promoter of the event, thereby implicating Heavy D as a promoter also. The last argument was raised in the event that Heavy D was not declared a promoter of the event in his own right. Can you imagine? Imagine your friend hitting you up. Now, mind you, Heavy D, like they said in the documentary, is the person that introduced, they're both from Mount Vernon, right? Right outside of Harlem or the Bronx, whichever one, but they're both from the same area. I don't know New York, so y'all correct me in the comments. But yeah, so they're both from that same area. He would knock and knock and knock on Heavy D's door to get him in good with Andre Harrell. He gets him in with Andre Harrell, and they throw this party. Can you imagine how pissed I would have been as your friend who has been helping you, and now you got me with this high-ass bill, and people have died? Oh, no. Okay. So we did that. The court finds that Heavy D and Combs cannot be construed as joint venturers. Okay, so the court is saying, no, this is Puffy's party. This is not Heavy D's party. All right. There is nothing in the record to indicate that the parties conceived of themselves as joint venturers. This was not a theory made known at any time before trial and discovery or motion practice. Nothing of this sort was contained in the disclaimer letter, nor was it alleged by National Union in the complaint. Neither was there anything to show that the parties' intentions was to form a joint venture. So that's great. That's great. This issue, never having been raised prior to trial, cannot be raised now, especially since National Union failed to make a motion to conform the pleadings to the proof during or after trial. So they're basically like, you should have raised that before, and it's too late now. The court notes that the insurance policy in dispute is a commercial general liability policy. The policy covers bodily injury and property damage for which plaintiff may be liable. Endorsement C limits coverage of the policy to an entertainer, theatrical manager, and or agent. Further, coverage is not provided for promoting activities to the extent of contracting with arenas, halls, theaters, and other places for theatrical presentations, whereby the business is holding harmless aforesaid facility. Endorsement D excludes concert tours if they are not reported in advance. Okay, so that's what they're trying to say right there. Endorsement D, the concert tour. So they're saying, hey, you should have let us know beforehand that this is going to be a concert. Limits coverage of the policy to an entertainer. Okay. So I'm guessing in endorsement C, they're questioning if he is, in this particular instance, an entertainer. Okay, let's go down. There's no question that the policy covers Heavy D. This is the judge. As an entertainer under endorsement C for the personal injuries and the loss of life that occurred to those attending the basketball game event. To deny coverage to Heavy D, plaintiff has the burden of showing that one of the exclusions apply. As to the argument that coverage is excluded because of promotional activities under endorsement C, Heavy D did not contract for the event. Sean Combs did. Moreover, one could reasonably argue that this was not a theatrical event. The cases generally interpret such ambiguous exclusions strictly against an insurance company because of its authorship of the policy. This was neither a concert nor was it a tour. A concert, as defined by the American Heritage College Dictionary, is a performance given by one or more singers or instrumentalists or both. There is no evidence that anyone sang or played any musical instrument. I don't know if that's true, but anyway. Also, this was not any kind of tour, but a single event. Therefore, this exclusion exclusion does not apply. Neither does the exclusion under the binder excluding self-promotion apply. The plaintiff has not come forward with any evidence that Heavy D promoted himself. The court interprets his radio interview as advertising the concert, which is far different than promoting himself. Accordingly, it is decreed and adjudged that the National Union Fire Insurance Company of Pittsburgh is obligated to indemnify Heavy D with respect to the personal injury and wrongful death. That is amazing. And that was a $1.5 million judgment. So wonderful, wonderful, wonderful. I wonder if he ever got that money because he did die in 2006. So I don't know if he's seen the money himself or, his children, his family, if they received it. But very, very interesting to know that he was also implicated in this case. And with the injuries of everybody, just really a shame. All right, I'll see y'all in the next video. All right, the last one I'm going to do is sweet greens, and then I'm going to actually try and make some money as I